Ben, ask juror number 598 to come in. 598. Ma'am, if you'll come up.
So they play a point and then rotate?
Yeah, as soon as somebody misses, I don't know. Not taking the instruction very good.
We're ready for the jury.
All rise for the jury.
Good morning, welcome back. Happy Thursday. Everybody can have a seat. Did the jury follow the admonition last evening during the break?
Yes, sir.
Thank you very much. Let me revisit the issue of the admonition for the benefit of the jury and for the benefit of the gallery. The admonition is that the jury is to have no conversations with anybody about this case. Anybody who is interested in this case, lawyers, parties, witnesses, people in the gallery, you have to be very cautious that in the hallway, in the elevators, on the escalators, on the sidewalks, you don't have any contact or communication with any member of the jury, even if that's innocent or inadvertent. For example, if you're in an elevator and you want to talk about this case, it's not a good idea to have that conversation if a juror is on that elevator. That's inappropriate contact. So just be careful. It may be inadvertent, it may be innocent, but it's dangerous to a case. So be cautious. For the jury, in terms of what the future in this case holds, we talked yesterday when we broke about our prediction of what the lineup is going to be today. The defense is going to put evidence on. In all likelihood, you'll be done hearing testimony by the end of the day today. In all likelihood, tomorrow morning, that means that we'll give you jury instructions. I'll read them to you. You'll get final arguments from the parties, and then probably about lunchtime, the case will be submitted to you for deliberation. What we'll probably do is first thing tomorrow morning is let you pre-order lunch. The deputies will give you menus, and you can order what you're going to have for lunch. The state actually springs for that. One of the few things. They don't take that out of your $12.50. They pay for that in addition to that $12.50. So that when you go back at about lunchtime, the lunch will be delivered to you pretty promptly. That's just one less thing you're going to have to worry about. Now, it's up to the jury when you're back deliberating the case to take as much time as you need. I can't tell you, I won't tell you how long you shall deliberate. Tomorrow, because you'll get the case at about lunchtime, it is within the realm of possibility that you'll be here deliberating past the hour that you normally go home, 5 or 6 o'clock. It is also within the realm of possibility that, bless you, if your deliberations are lengthy, that you may have to be sequestered. Sequestration of the jury is mandatory in a felony case. So you may be here overnight tomorrow night. If that happens, if you haven't reached a verdict by late in the evening, there's a whole world of stuff that goes on to make accommodations available to you. You're actually taken by bus to a hotel. You're sequestered there for the evening. And if that occurs, then we'll come back on Saturday morning and let you continue deliberation until you've reached a verdict. So tomorrow, when you come in the morning, bring with you a bag with a change of clothes and with personal items, toothbrush, medicine, so that in the event that you are sequestered, you'll have those things and have them ready for you. Okay? Any questions from the jury? Yes, ma'am. Yeah, no, I don't think so, other than if you're in a place where you think you might get towed, but probably not. If you're here late, let's say hypothetically you don't get done until midnight tomorrow night. we will have people that will, deputies and mechanisms to make sure that somebody walks you to the car. So in terms of safety, you'll be okay. I just don't want you to park in a place where your car might get towed. So, maybe in a parking garage versus a on-the-street parking place. Okay. All right. The Commonwealth has closed its case. We next turn to the defense and see if they intend to put proof on.
Your Honor, Joshua Young calls Terry Zwicker.
Terry Zwicker, please. Push your button here. Mr. Zwicker, if you'll come up, I'm going to place you under oath again today. If you'll raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be truthful? Thank you.
Good morning, Mr. I have one question for you. To your knowledge, was Trey afraid of the dark?
No, sir.
Cross-examination. Any questions from the jury on that issue? I think we have a question. Okay. If I can have the attorneys up here. Very much. You can step back, step down. Mr. Young, the next witness.
Joshua Young calls Bridget Fraley.
Bridget Fraley. Ms. Fraley, if you'll come up to the witness stand, please. You let me place you under oath. Do you swear or affirm that the testimony you're about to give will be truthful?
Yes, sir, I do.
Thank you. Have a seat. Be comfortable. I encourage you to sit up close to the microphone. It's adjustable for your height. Keep your voice up good and loud so we can all hear your testimony.
Yes, sir, thank you.
Ms. Fraley, would you introduce yourself to the ladies and gentlemen of the jury, please?
Hi, my name is Bridget Fraley.
Where do you work?
I work for the Kentucky Cabinet for Health and Family Services.
What do you do?
Well, currently, as of August the 1st, I was promoted. I work in quality assurance in Frankfurt, but from December the 1st, 2010 to July 31st, 2013, I was employed here in Louisville at the at the Crimes Against Children Unit, Child Protective Services.
On May 17th of 2011, did your supervisor direct you to interview Mackenzie Savage?
Yes, sir.
Did you do so?
Yes, I did.
Where did you interview her?
I interviewed her at the paternal grandmother's house. Her name is Frida Savage.
You interviewed Lindsay?
Yes, I did.
Did you ask her details about the last time she saw Trey?
Yes, I did.
Did you get information from her concerning the last time that she saw him?
Yes.
What did she tell you was the last time that she saw Trey?
Um,
And you can put it in context, but just in that conversation of how it built up to that.
She recalled that it was on a Tuesday. She took a bath about 7 p.m. She and Trey were eating some chips on the couch. She took her bath first, came out and said she was going to sleep on the couch. Trey took a bath after she did, and she recalled that the last time she saw him was when he came out of the bathroom and that he went upstairs.
Did she ever mention seeing him leave to go outside while she was sleeping on the couch?
No.
And the last question is, was she forthcoming with information to you, or did you have to ask her leading types of questions to get this information? Was it more of a narrative, or were you pulling stuff out?
No, it was more of a narrative.
Thank you.
Cross-examination.
No, Your Honor, I don't.
Questions from the jury, Ms. Rayleigh? May we release this witness?
Yes, Your Honor.
Thank you very much, Ms. Rayleigh. You're free to go.
Thank you, sir.
Next witness.
Joshua Young calls Cindy Gunther, please.
Cindy Gunther. Ms. Gunther, if you'll come up to the witness stand, please. Before you have a seat, I'm going to place you under oath. You'll raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be truthful? Thank you. Have a seat and be comfortable. I encourage you to sit up close to the microphone. It's adjustable for your height. Keep your voice up good and loud so we can all hear your testimony.
Gunther, would you introduce yourself to the ladies and gentlemen of the jury?
My name is Cynthia Gunther, and I'm the aunt of Joshua Young.
Do you know the people that are involved in this case, including, did you know Trey Zwicker, did you know Amanda Campbell, Joshua Gowker, generally the people that are involved in this case?
Yes, I did.
How did you know them?
Josh Gowker is Joshua Young's daddy. I've
You
known.
know through the neighborhood? through the drive?
Yes.
And do you have some connection with that neighborhood?
Yes.
Did you grow up in that area?
Yes, I grew up in that area.
I want you to focus your attention only on the funeral in this case that occurred on May 16th, 2011.
Yes.
Do you remember the funeral?
Yes.
Do you remember how you got to the funeral?
Yes, I went with Josh Gowker, Amanda, and Joshua Young.
Can you describe Joshua Young's demeanor in the car going to the funeral?
Very sad, very distraught, teary-eyed.
Was the same for Amanda?
Yes, she was moaning pretty much. Had dark glasses on, really couldn't see if she was crying or not.
Do you remember where the funeral was?
Yes.
Where was it?
It was at Evergreen.
And there was a service?
Yes.
And who were the pallbearers, do you remember?
I only remember one specific, which was my nephew, Joshua Young.
And what was his demeanor during the service?
He was very sad, held his head low and teary-eyed.
And how close were you to Joshua Young during the service?
I was right beside him.
And what about when you exited the area where the funeral was? How close were you to him?
Where the funeral was?
When you exited, did he walk out with you?
Yes, I was right there.
How close were you?
With a few feet.
Within a few feet while he was walking out
Yes.
with the casket? And what was his demeanor when he was doing that?
He was waiting and he was very sad.
That's what you observed.
Yes.
What about when you left? What was his demeanor?
He was still very upset.
Do you know if he actually shed tears or said teary-eyed? Was he crying? Was he...
He was teary-eyed. At times he cried, teary-eyed again.
Thank you.
Cross-examination.
Nothing for this witness.
Any questions from the jury? May we release this witness?
Yes, Your Honor.
Gunther, thank you very much. You're free to go.
Thank you.
Defense, next witness.
Judge, our last witness is Allison Miller.
Allison Miller. Ms. Miller, if you'll come up. Before you have a seat, I'm going to place you under oath. If you'll raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be truthful? Thank you. Have a seat. Be comfortable. I encourage you to sit up close to the microphone. It's adjustable for your height. Keep your voice up good and loud so we can all hear your testimony.
Would you introduce yourself to the ladies and gentlemen of the jury, please?
My name is Allison Miller. I work for the Cabinet for Health and Family Services.
What's your occupation?
I'm an ongoing family service worker for children 12 and under.
What were you doing in the fall of 2010 and the spring of 2011?
As far as on the case,
Well, where were you employed then?
I was employed with the Cabinet for Health and Family Services.
And how were you involved with Joshua Young?
I've had his ongoing case from 2007 until 2012.
And I want to, we're just going to talk about two very narrow things. But first, you do a case plan for the families that you're
Yes,
working with?
we're required to do one every 6 months.
Part of the case plan that you do home visits.
Yes, it is. That is included in one of the objectives in the case plan, is that they have to meet with us monthly.
One of the reasons you do that is to see how things are going in the home.
Yes, we have to provide reasonable efforts to the family and assist them in possibly reuniting with their child.
How many home visits did you do in 2011?
I visited the home once every month.
And any time in 2011, during a home visit, did you see Trey and Joshua Young together?
They were observed in March of 2011 and April of 2011.
Can you describe the demeanor, what you observed, you saw Trey, what you saw Joshua doing, and how they were acting? Can you just describe how they were acting the times that you saw them in 2011?
When I showed up at the home, they were sitting together on the couch playing video games. Very relaxed, kind of joking with each other. Gowker at that time had asked Trey and Mackenzie to go to the other room so he could talk to me, and the children got up and left. Joshua stayed with Gowker and myself.
The times that you visited with them and observed, did you ever observe any negativity, hostility, anything at all that would lead you to believe that there was a problem between these two boys?
No, I did not.
Cross-examination.
Just very briefly, Your Honor. So, ma'am, it's your testimony that you observed Trey and the defendant together on 2 occasions?
Yes, that's correct.
And the one time you spoke about, you came into the house and they were playing video games at that time?
That's correct.
And then they left the room. Trey left the room and the defendant stayed in the room?
That's correct.
So, would it be fair to say that that observation lasted a moment or two?
Probably a minute.
Okay. And it was your agency that helped Young and Gowker get reconnected?
We set up case plans and court orders to reunite them. Yes, we have to, required by the law.
Thank you.
Redirect. Any questions from the jury? Okay, questions? am unable to ask any of the questions tendered. Thank you very much. You're free to go.
Thank you.
Any additional proof from the defense? Okay, ladies and gentlemen, you have heard all of the evidence that you are likely to hear from the defendant. Can I have the attorneys up here just a minute? We are going to come back tomorrow morning, 9 o'clock. First thing we'll do is I'll give you the jury instructions. The lawyers will give you their final arguments, and the case will be submitted to you for deliberation tomorrow. So it's very important, although you've heard all the proof, that the admonition still applies. Don't discuss the case among yourselves or with anybody else. No independent investigations. Don't watch, listen, read any media coverage about the case. Get a good night's sleep. We'll see you back here at 9 o'clock. When you come back tomorrow, bring your suitcase with you, with your toothbrush and your medicine, and we will figure out a place to put it. We may pile it on that table over there, or we may put it in the jury room. Find something to do with it. But we'll see you back at 9 o'clock in the morning. All rise for the departing jury. Jury's out of the courtroom. You all can be seated. What I would like to do is spend some time working on the jury instructions. Let me, just as a housekeeping matter, review the exhibits that are in. The Commonwealth has introduced 1 through 131. The defense has introduced 1 through 6. The defense also has 2 avowal exhibits, 1 and 2 that we've discussed. What is your all's pleasure about looking at the jury instructions?
I think we're prepared to talk about that now.
Okay, we can do that. All right, I have a draft that was tendered by the Commonwealth. They've tendered instruction on murder and tampering with physical evidence, with 2 definitions: intentionally and complicity, presumption of innocence, including the provision that the defendant is not compelled to testify, unanimous verdict, and then 2 proposed verdict forms. Pretty straightforward instructions.
The proof in this case, we would assume is confusing. The law requires unanimous verdict. The Commonwealth has complicity and murder lumped into one instruction.
Wait a minute, say that again. The Commonwealth has murder and complicity lumped into one instruction. Okay.
If there ever was a case where there should be 2 separate instructions on complicity and murder, this would be the case. If it's lumped in one instruction, half the jurors might think, theoretically, that Joshua was the principal that actually did this by himself. They might think that he somehow assisted, although that evidence is, I just think that there's not much evidence at all. I think we're engaging in a lot of speculation of what happened. But theoretically, they could believe that Joshua did it on his own, that Gowker set it up, did it on his own. They could believe that they did it together. They could believe that Joshua maybe did something to aid or assist and not actually cause the beating. And as I said, the jury should speak very clearly with one voice as to what they believe happened in this case. I think they need to come to some agreement, and I decision. So what we're asking the court to do at this point in time is to consider a separate complicity instruction. I have pulled a separate complicity instruction out of Cooper's. I can show the court an example of that. And I'll give the Commonwealth off the copy. I haven't drafted one, but may I approach?
Yes, sir. What section is it in Cooper?
10, 14. But this is to show the court that actually, as far as instruction forms go, that it is proper to do so. And also, I think that just by lumping everything together, I think the court needs to, with respect to the definition of complicity, the court needs to instruct specifically on what the facts show that our client did. An example is the Commonwealth has not tendered a wanton murder instruction. We would agree that this is not wanton murder because whoever did this killing clearly intended it to happen because of the extreme violence and force that was used. It's obvious to everyone this was an intentional murder. So they are not asking for a wanton murder instruction. Similarly, I think it's clear from the evidence, there is no evidence that our client solicited this murder. So I would object to instructing the jury to speculate about something that is not in evidence. There is no question, there is no evidence that Joshua Young commanded the murder. So we object to instructing on that. I've argued in my motion for a directed verdict that there is no evidence that they engaged in a conspiracy. I mean, it's all done by inference. There's an inference that there was a conspiracy. There are no facts presented there was a conspiracy. There's no person that overheard them talking about this crime before it happened. There would need to be some evidence. That's what conspiracy is. There's a separate legal definition for conspiracy, and conspiracy itself is a crime that has not committed. It's a plan where there's a substantial step involved. So this definition of conspiracy means something different than the crime of a conspiracy. I have a problem that conspiracy is not even defined. Conspiracy has a lay definition. I know that it's written in the statute. I think it's vague anyway, but our objection to that would be to instruct them engaging in a conspiracy because there is no direct evidence of that. We think it has to be direct evidence. The only argument that I can think of is that there is circumstantial evidence of a conspiracy. The court has found the evidence sufficient under the court's ruling, then I guess there was the assumption that the two could have conspired together, but there is no direct evidence. And then you have to do that with another person to commit the offense. And then there has to be aid. There has to be aid. There's no testimony of aid. There's no testimony of counseling. There's no testimony of attempting to aid. So really, this all goes back to our motion for a directed verdict. We don't think that there's any evidence of that, and we're overruled. And the law requires me, and I hereby at this point in time do, based on our arguments for directed verdict, based on the insufficiency of the evidence, we do object to instructing the jury on murder and both murder and tampering with physical evidence. But it's my understanding that that's been overruled. But to preserve the record, I am formally objecting to that. So if you're going to instruct the jury, I think the court should limit to what the evidence shows. You shouldn't throw out a textbook definition of complicity because the court has not, they're not asking the court to throw out a textbook definition of murder. They're limiting that to what the facts show. Again, and just for the record on the tampering too, we made our arguments on that. I said we do object to instructing on that. But I'm assuming that the court would instruct based on the acts that Joshua did as testified by
Joshua Young?
Joshua Young.
Okay.
So number one, what we're asking the court to do is to give a complicity instruction separate from, that's in the alternative. If you're going to instruct the jury at all, we're asking you to give a separate complicity instruction. The evidence is convoluted. The jury, if they're going to sentence our client, find him guilty and resulting in a lengthy prison term, they need to speak with one voice. They need to decide what happened in this case. We need to know what they found. If you lump it together in one instruction, we will never know what they found.
Well, they don't make findings of fact, do they?
Do they make findings of fact?
Yeah. Are you proposing that we're going to tender an instruction to the jury where they're going to write down what their conclusions and findings of fact are?
They speak through the verdict forms that
Right.
you give them.
Right.
So the findings of fact, they speak through the form. I'm asking that they speak through the form so we'll know complicity or principle. I think that's very important in this case. I read the new Peacher case that just came down. The court's probably familiar with that. I can give you the site on that.
I would love to read it. I'm not familiar with it, to my knowledge.
I have this idea if you would like that.
Yes.
It is 391 Southwest 3rd, 821.
391, 821.
Yes.
Okay.
Yes, and the defendant did not prevail in that situation, but I think when you read, that was you may remember this case. It was tried 6 months ago here in Jefferson County, and it involved homicide of a child, and the jury struggling again with limited information about who played what role. It is a good case for the court to read. I think it will give you some guidance. I don't think it necessarily says that you have to do what we're asking you to do. I wanted to make you aware of what the law was, and I wanted to make you aware of all the confusion that might arise. I can't understand why the court wouldn't give a separate instruction on complicity. I don't see how anybody's being jeopardized by that. Commonwealth's not being jeopardized by that. Again, it's...
I would ask that you tender a written proposed instruction, the separate instruction that you've discussed on complicity. I appreciate your giving me a copy of Cooper's 1014. Cooper's is obviously a source that we all look to for guidance in terms of jury instructions. But if you will tender to the court a separate proposed complicity instruction, that will be helpful to me.
Let me go on and say, understand that Cooper's is Cooper's, complicity is complicity, but when the law changed, it is absolutely clear that an accessory after the fact is not an accomplice, and that goes way, way back in Kentucky common law. One of the cases that I looked at is Hall versus Commonwealth 248 Southwest 2nd 417. And in this case, I think the instructions need to be extremely clear. The jury needs to know that if they believe that Joshua Young did have this, whatever it was, the evidence or a dummy bag or whatever, if they actually believe that that's true, that helping, if they believe Galper did it, Young helped after the fact, that he is not guilty of being a compliciter. And I think the definition in complicity is so broad because it talks about assisting. It doesn't make it clear that assisting after the fact does not make a person a compliciter. Perhaps, if you're there at the scene and you do stuff, but if you help somebody after the fact, you're not an accomplice. Dr. Mudd was convicted of helping John Wilkes Booth help him, heal him after the assassination of President Lincoln. But that did not make him a complicit, although I think that he was saying that for a long time. That's an example. So if you help someone after the fact, you're providing some assistance, and the definition does not draw a line on at what point that begins and ends. So I would tender another instruction. I can draw one up, and I'm not sure this has ever been dealt with, but I have grave concerns that the instructions might cause some confusion, and they may be tempted to convict him of murder if they believe that he helped Gallagher after the fact. I think it's our client's intention to ask the court for an instruction on facilitation to murder. Again, I'm trying to make the argument for him. I've argued to the court. I don't see where there's evidence for that. Because, like I said in my arguments, I don't see any evidence at all other than people saying our client said he did this. Gallagher saying that our client did this. And taking the bag and dumping it. That's the entire case. So I'm at a loss, and I would draft one, and I would do that because our client wants a facilitation instruction, wants a lesser included. Speculatively, I guess if they could find him guilty of complicity, I guess that they could find him guilty of doing the same thing without having the intention. And that's the only difference between facilitation and complicity. You help, you want it to happen, or you help and you don't want it to happen. It's really not in evidence, but they could maybe believe that he didn't want it to happen, and Gallagher coerced him into assisting in some way. We're way out there, but the evidence is lacking. So what I will do, because our client wants it, I will tender an instruction for facilitation. But I have to confess again, I think to be consistent, the evidence. Time limit on the assistance issue. In other words, he assisted Gallagher up to some point in time. When it ended, the assistance was after the fact. Maybe if you believe that he assisted Gallagher after the fact, you shall not convict him of murder or something like that. I've been struggling with that as well. These are the problems that we've been talking about, that we've been researching, and those are the highlights of the arguments that we would like to make in connection with the instruction.
All right, if you would be kind enough to tender your proposed instructions to the court by 2 p.m. today, is that reasonable?
Yes, sir.
And I'll probably just be in here working, so although the courtroom will be locked, you can buzz and get in and just tender them to me or to Ruthie. Thank you. Any response from the Commonwealth?
Well, Judge, I've never heard of a case where complicity was split out like this.
Can I interrupt you?
Yes.
You could also email them to me. Email is fine.
I'm afraid it might bounce back, but I can
Well,
try.
okay.
There is evidence to support either theory. Circumstantial evidence for complicity may suffice. That's in the Combs case, 316 Southwest 3rd, 877. And the jury is allowed to consider both. I've never heard of it being split out. I would ask for time to research it. I don't want to incorrect jury instructions point, I don't want to reverse on this issue. I feel that the jury can get an instruction on both principal and complicity in one instruction, just like we can submit an assault or wanton murder instruction, and they don't have to be unanimous on whether it's intentional or wanton. It's still a unanimous verdict, but I would ask for time to research it.
And the Peacher case does talk about that unanimous verdict issue, and I said it doesn't support our argument. I wanted you to know that, but we still feel like it's an issue, and we would like to win that to this court anyway, and see what we can do with it.
Let's reconvene at 3 p.m. this afternoon. I will have a good solid draft of what I intend to instruct on at that point in time. And you all will have another stab at looking at those and making additional arguments. And that way we'll be able to adjourn at a reasonable time today and send you all home with what I'm going to instruct on so you can be ready for final arguments. Okay? Thank you all very much. See you back at 3. That's his decision. Doesn't make any difference to me. The question was, he's coming back at 3. Does he have to be dressed out?
I think you probably wants to say.
Yes. Thank you.
I'm sorry, I misunderstood. There's stuff that you might want. I wonder if she was thinking of teacher or not. Yes.
You want to try to grab her? Well, I was just going to try.
Grab her and push me down. And I don't want to sign off on it, but it's my case. I specifically argued to the jury. Half of you can think that it's one. It doesn't matter.
People are never happy when they say neighbors.
So,
I'm always thrilled to see you.
Thank you.
There's a possibility we might be here on Saturday. I might have somebody else there. I don't run over 40 hours for the week. I can't.
Maybe they should pay you overtime.
Part-time.